Welcome, everyone. Before we begin today's presentation, please note that this seminar is being recorded and closed captioning is available. If you wish to turn on closed captions, please click the live transcript button at the bottom of your screen and select Show Subtitle. Thank you, and we will begin shortly.
Hello, everyone, and thank you for joining our virtual estate planning seminar today. My name is Carolyn Thompson, and I'm the Director of Philanthropy at the University Hospital Foundation. I am so happy that you are able to join us for this event. I would like to first acknowledge that the University Hospital Foundation is located on Treaty 6 territory, and we respect the histories, languages, and cultures of First Nations, Métis, Inuit, and all First Peoples of Canada, whose presence continue to enrich our vibrant community. As Emily mentioned, today's session is being recorded. We will send the link to everybody who's registered to our invitation over the next few days. Today, we are going to hear about the benefits of estate planning, how to get started, and how a planned gift can help you achieve your legacy goals. For your benefit, we will have a Q&A session at the end of our presentation, so please do submit any questions that may arise during today's presentation through the Q&A button at the bottom of your screen. Our legal and financial planning experts will attempt to answer as many of your questions as possible during the Q&A session. You will also hear from Dr. Jhamandas, who will be sharing exciting developments on his career-long quest to find a cure for Alzheimer's disease. A researcher who has received support from the University Hospital Foundation, Dr. Jhamandas is familiar with the incredible role that the community support has played in making the University of Alberta Hospital site one of the leading medical sites in Western Canada. To tell you more about the work we do and why we do it, and to introduce our guests, I would like to now welcome Fearless Agents of Hope leaders, our Chief Culture and Experience Officer, Amanda Radakovich. Amanda?
Thank you, Carolyn. It's a pleasure to be here today and exciting to see so many people interested in learning more about estate planning. The University Hospital Foundation wants to help people live long, active, and fulfilling lives, especially those who are seriously ill or injured. As agents of hope, we boldly seek solutions to seemingly insurmountable challenges, matching the determination and intensity of our medical teams we support. In the past 10 years alone, generosity from donors, corporate partners, and legacy gifts have contributed nearly $220 million towards bringing some of the best care in the world to our hospital site. Our hospital delivers services to patients facing life-threatening brain, cardiac, gastrointestinal, and neurologic conditions, to name a few. Through our donors, we provide our medical teams and researchers with the technology, equipment, and ongoing financial support to advance patient care, create new knowledge, and inspire breakthrough discoveries that impact health and healthcare around the world. I would also like to share how each of you can become a member of our proud and very exciting Gold Leaf Society and receive news and updates in our Legacy newsletter and earn a special place on our Legacy donor wall. When you share your meaningful intention with us to leave a bequest in your will to the University Hospital, you automatically become a Gold Society member. This means your gift will not only be remembered by the patients who benefit directly from your generosity, but also by future generations of Canadians who may not know who you are, but will be inspired by what you have done. If you'd like to have more information about our Gold Leaf Society, please visit our website at give2uhf.ca to learn more. And now it is my privilege to introduce our first guest speaker for today's event, Dr. Jhamandas. Dr. Jhamandas is a distinguished professor in the Division of Neurology at the University of Alberta and a clinician scientist at the University of Alberta Hospital. He is also the lead investigator of critically important research that may one day lead to a cure for Alzheimer's disease. And that is what he will be sharing with us today. Dr. Jhamandas, the floor is yours.
Thank you very much, Amanda and Carolyn, for your very kind and generous introduction. Ladies and gentlemen, it is my singular honor and privilege to be invited this afternoon to share with you some of the exciting developments in Alzheimer's disease that have the potential to be a game changer for this devastating condition, and in the process benefit patients, their families, and society at large. Specifically, I will share with you our story concerning our journey to find a treatment for Alzheimer's disease. This quest would not have been possible without the unwavering and unconditional support of the University Hospital Foundation. So we'll get started, and next slide, please. So there are many mountains and science in terms of finding cures for diseases that beset our modern society. And I would tell you that there is no bigger mountain to climb than finding a cure for Alzheimer's disease. And to borrow a sort of phrase from the legend of King Arthur, this really is a cure for Alzheimer's disease, indeed, maybe the holy grail that we have been looking for a long, long time. So let me frame for you the scope of the problem in terms of what we are dealing with. Next slide, please. So Alzheimer's disease is the most common cause of dementia. And dementia is a general term that's applied to global loss of intellectual and cognitive function. And there are many causes of dementia, but as you can see from this slide, almost 90%, 80 to 90% of all cases of dementia are due to Alzheimer's disease. So it's estimated that 1 in 9 Canadians have this condition at age 65 and 1 in 3 at age 85. And I would tell you that probably 1 in 3 at age 85 is an underestimate, and it's probably closer to 1 in 2. And in Canada, we have approximately 500,000 people who live with Alzheimer's disease. And in Alberta, that would translate into 50,000 people with this condition. Now, 50,000 out of a population of 4.5 million sometimes may not seem as much when you compare it to perhaps cancer, heart disease, stroke, and so forth. But I submit to you that one has to look at this condition from a very different lens. Alzheimer's patients, sufferers, their lives affect people around them. So they have spouses, significant others, they have children, they have parents, they have brothers and sisters, and very close friends. So if you take one person with Alzheimer's disease and their condition or their life affects a dozen people around them, you multiply 50,000 by a dozen, and that's 600,000 people directly or indirectly affected by this condition. That's 1 in 6 or 1 in 7 Albertans. And that, I think, really brings home the scope of this condition. And in this day and age of healthcare costs, I don't have to tell you how much it costs to keep people who have Alzheimer's disease in the community, and also to look after them in our facilities, long-term care facilities that we have. Now, I'm going to be showing you some science and some medicine, but let me try and put a human face to this condition. Next slide, please. The human face is captured in this slide. And this is a slide of a series of portraits that were made by an artist, Mr. Uter Molan, who lived in London, UK in the 60s, 70s, 80s, 90s, and early 2000s. And he was an artist. And in 67, he began to make self-portraits of himself. And you can see that in 1967, he drew himself, handsome young man there. Now, in 1995, he was diagnosed to have Alzheimer's disease. And he made it his mission to, in spite of this condition, to try and paint himself every year. And you can see these series of very heart-wrenching portraits, which show really a dissolution of his self-image and how he viewed himself. And by 2000, you can see that it's barely recognizable that this is a portrait. And he died shortly thereafter. An artist said, you know, her husband really died the day he was diagnosed to have Alzheimer's disease, and he could not paint anymore. So I think this really captures the essence of what the disease is, does, and its implications on people around them. Next slide, please. So we have understood a lot about Alzheimer's disease and its biology in the last 40, 50 years. In fact, the disease was first described over 100 years ago by Dr. Alzheimer, a neurologist in Germany. Now, two of the key features of Alzheimer's disease are abnormal proteins that are deposited in the brains of Alzheimer's patients in areas that are important for learning and memory. And these proteins are called, one of them is on the slide called neurofibrillary tangle or tau protein. And the other one, which is on the bottom right-hand side of the slide, is called the beta amyloid plaque. This is a sticky protein that is found in large deposits in the brain, and it is felt to be very critical in causing dysfunction and death of brain cells that eventually results in dementia. So there have been tremendous amount of efforts to try and either stop generation of this protein or get rid of it. Next slide, please. And so this has really been the chase to try and find a solution to this condition, partly by getting rid of the amyloid because it is so toxic and produces death of brain cells and causes dementia. Now, unfortunately, the next slide will show you what our efforts have yielded. This is a slide from 18, change in the intervening 4 years. And what it tells you is that of 244 drugs that were tested over a matter of 10 years from 2002 to 2012, in 413 clinical trials, not a single one of those trials yielded a treatment for Alzheimer's disease. So it has been a dismal situation, to say the least. Next slide, please. So we have been at this for over 20 years now. And around that 20 years ago, we developed a notion that certain drugs that were being developed for diabetes might also be beneficial in their use to treat Alzheimer's disease. Now, it has been known for a long time that diabetes and Alzheimer's disease share what we call an epidemiological linkage, meaning if you have diabetes, your odds of getting Alzheimer's disease are considerably higher and vice versa. So companies were developing drugs to treat diabetes, and we felt that we should maybe examine some of these drugs for their potential to at least allow us to treat Alzheimer's disease. And one of the drugs that we focused on early was something called AC253. And AC253 is a peptide or a protein. It consists of a string of amino acids. And over the ensuing 10 years or so, we showed that this drug, AC253, protected brain cells in the dish from the toxic effects of amyloid protein. Also, when we were able to get sufficient amount of this drug into the brain, it appeared to improve learning and memory in mice that had developed Alzheimer's disease. So we felt pretty good. Now, by this time, many of you are saying, have I heard AC253 before? And indeed, you may have heard of AC253. The next slide will show you why. AC253 is actually a flight from Edmonton to Vancouver. It leaves every day. It may not get you there on time and you may lose your luggage, but it is AC253, and that's the same name as the drug that we have been using. Now, apart from the fact that AC253 is an Air Canada flight, one of the concerns with AC253 is that it's what we call a peptide, meaning it's a string of amino acids. So if you take it by mouth, it is going to get metabolized or chewed up in the bloodstream before a sufficient amount of this reaches the brain. So it has been a real challenge to try and get sufficient amount of this drug into the brain, which is obviously necessary if we are going to extend this and treat the human condition with these drugs. So around 4 years ago, we developed a collaboration with Doctors Lon Terrell, who's a very famous virologist that you've heard of. Lon was one of the first people to develop a drug for hepatitis B. It was developed right here at the University of Alberta. And also the other collaborator is Dr. Michael Houghton, who's also a very famous virologist. And Dr. Houghton won the Nobel Prize in Medicine and Physiology in 2020. So we started putting our heads together, and both of these outstanding scientists have created Virology Institute here, the Applied Virology Institute and the Li Ka-shing Institute of Virology. Next slide, please. And one of the strengths of this Virology Institute is that it has the ability to do what we call artificial intelligence, and it has a lot of computational. So what in Mike's group and other scientists, talented computer scientists in this institute did was they took our data from the peptides, AC253, and they started to model it. So they started to make models of this peptide. And one of the things that we were trying to find was something called small molecule drugs. Now, small molecule drugs are drugs that you use for blood pressure, cholesterol treatment. In everyday use, we use small molecule drugs. But the challenge is to find small molecule drugs. And we were, through this computational facility that is present here, we were able to screen 7 million molecules using this IBM computer. And that yielded for us a couple of hundred compounds that appeared to have the same activity that AC253 had shown. So we started to then work with these compounds and start testing them. Next slide, please. So this, I don't want to complicate things for you in this slide, but the point is that we tested at least 150 of these compounds. And I want you to just keep an eye on a compound that's on this slide called AVI 9064, which is the fourth bar from the left here. And that is the compound we thought was the most promising of the lot in terms of recapitulating what we had seen with AC253. So we started to test this compound further. Next slide, please. And one of the early things that we tried to determine was, can it protect brain cells in the dish? And the experiment is very simple. On the bottom left-hand side, you can see brain cells, and you can see green and red over here. And it's very simple. Green is alive cells, and red is dead, meaning those cells are dead. If you apply amyloid in 2 brain cells in a dish, you cause cell death. And that is shown with these red number of profiles of cells, brain cells that you see in the slide. On the far right-hand side is the similar dish that was also, the cells were also treated with amyloid beta, but on this occasion, we gave the drug 9012 and 9064 before we put the amyloid on. And you can see that there are very few red cells in this dish, meaning that these cells were protected by the drugs that we had provided. So we started to get quite excited, and the next step obviously was to try and test these compounds to see if they could improve learning and memory. Next slide, please. And we can test this in several ways, but one of the major advances in Alzheimer's field has been that we have been able to genetically engineer mice that can develop Alzheimer's disease. So these mice are born normal, but by 6 months of age, their brains are riddled with amyloid plaques, much like the human brain, and they also have difficulty with memory and learning. And in this slide, you can see 2 brain sections. One is from a normal aged mouse, which doesn't show any green at all. And at the bottom, you see a brain section from an Alzheimer mouse, and each of those green dots that you see is the amyloid plaque. And you can see that it is totally riddled with the amyloid plaque. So we used these mice as a model to test our drugs. Next slide, please. And one of the ways that you can test memory is you can also test it in a petri dish, if you wish. And what we do here is we take of the brain, campus, which is the seat of learning and memory, and we record electrical activity from this brain slice. And on the right, you can see that there are these blue dots, and then there is this HFS, which is a series of shocks that are applied to the brain slice. And after you've applied this series of shocks, when you apply a single shock, you get a significant increase in the signal. And that increase in signal can last hours on end. And this is considered to be a surrogate of memory in the dish. Next slide, please. Now, Alzheimer's mice show a diminished memory when you record electrical activity, and that is shown in the red trace on this particular slide. So you can see that the red is quite low compared to the other traces over here. If you apply the drug 9064, you can see the trace, which is now in yellow, that it is now restored to levels that you might see in normal mice. So this was a very interesting and important discovery that, at least in the dish, it seemed to improve learning and memory. So we next proceeded to examine this in live mice, and we administered the drug every day for 5 weeks by injection to these mice that had Alzheimer's disease already. And we tested memory and learning. So next slide, please. So you might say, how do we test memory and learning? Well, one of the ways that we test memory and learning is that we have a 6-foot diameter pool of water. And in that pool, we place a platform, which you can see to the left of the slide. It's in white over here. And we introduce mice into the pool. So they find the platform. So please click the video. So you can see the mouse is now lowered into the pool. And this guy is going to run around. He really wants to find that platform. Now this guy is an Alzheimer, so he's not bright, and it's going to take him a few tries to find that. He'll find it. And we can time this. We can say it is going to take 60 seconds or 80 seconds. And you can see he found the platform. It took him about 30 seconds or so to get up there. Then he comes out, dries off under a heat lamp, and he feels like he's sitting on a beach in Hawaii. But we can, every day, when you test these mice, when you test them every day, they get better at locating the platform. Okay? So it is a way of showing that they are learning every day. Now, the human equivalent to this might be that, let's imagine that you move to a new neighborhood and your grocery store is a 15-minute walk away from where you live. The first day it's going to take you 15 minutes to get there. The next day, because of the cues that you see in your environment, it's going to take you maybe 12 to 13 minutes. By the end of the week, if you're doing this every day, you'll probably be able to do it in 7 or 8 minutes. So the principle is exactly the same. The mice learn to find the platform in an efficient way. So next slide, please. So the next slide, actually, if you go advance one more, please. Now, this slide shows you just look at the top trace here. This slide shows you this blue trace, which are Alzheimer's mice that did not get the drug. So you can see that the first day it took them 100 seconds to find the platform. By the end of 5, they were about 75 seconds. So they got better. But look at the orange trace below it with all these stars. These are mice that got our drug every day by injection for 5 weeks. And you can clearly see that these guys show a marked improvement in being able to locate the platform in an efficient manner. At the bottom of the slide is something called novel object recognition, which is another way of measuring behavior and cognition in the mice. Now, the orange trace here, in this test, mice are put into a glass chamber, and there are toys at each corner of the chamber. And what they do is that most mice will go and explore these toys. And after a while, they'll get used to the toys. But if you introduce a new toy, they will go and explore it even more. And Alzheimer's mice, which are shown in orange here, don't show that. They tend to be more apathetic. They really don't want to go around and explore anything. But if we give those same mice drug, you can see in the green here that they start to now explore. So they are not as apathetic. They tend to be more engaged in trying to understand more about their environment. Next slide, please. Now, once we completed the testing of memory and stuff in these mice, we also looked at the brains of these mice. Specifically, we are looking for amyloid deposition, amyloid plaque deposition. And in the top slide over here, you can see that there on the right-hand side, the brain section shows those green dots that I'd shown you earlier. And there is a lot of green dots, meaning there's a lot of amyloid in this drug. Below is a section from a mouse that was treated with the drug. and you can see that there is a significant reduction in the amyloid plaque deposition in these mice. Next slide, please. Now, one of the other features of Alzheimer's disease is that there is brain inflammation as well. And you can see that the slides on the left-hand side show you these green profiles or green objects, which are what we call microglia. Microglia are these immune cells that are involved in inflammation in the brain. And you can see that in a mouse on the left-hand side that did not get the drug, there's a lot of these cells that cause inflammation. Whereas if you look on the right-hand side, these are mice that got the treatment for 5 weeks, daily treatment. And you can see that there is a significant reduction in the inflammation. Next slide, please. So, we have obviously extended these findings much farther. And one of our next steps is to try and find drugs that are even more effective than the ones we have. But particularly, we want to be able to find drugs that we can give by mouth as opposed to by injection. Not that injection would not be an option, but really it would be preferable to give drugs by mouth in a manner that sufficient amount of it would get into the brain. So far, we have not seen any toxic effects from these drugs. These animals have not developed diabetes or any abnormalities of other organs or unacceptable side effects, but we still have to do further toxicity studies to ensure that these drugs. We want to try obviously move forward and develop these drugs and compounds under what's called good manufacturing practice, meaning that they can then be given to human patients in phase 1 clinical trials, which first assesses safety, tolerability of the drug, and then go on from there to give it to patients who have Alzheimer's disease. Now, research is an expensive business. And, the type of projects that we are engaged in are what I call high risk, high reward, meaning that, the probability of failure is there, but the rewards potentially are phenomenal. And, we want to continue raising funds to develop and test efficacy of these drugs with the goal of eventually giving it to our patients. Next slide, please. So I just want to acknowledge the people who do the work, people in my laboratory, the Li Kai-shing and applied virology team of Drs. Houghton and Terrell, and obviously the support of the University Hospital Foundation has been critical to this. Next slide, please. I also want to leave you with this slide. If you're an Alzheimer's patient or you know someone who has Alzheimer's disease, that, I grew up in Africa, and one of the areas that's near to where I grew up was this place called Ngorongoro Crater, which is one of the most beautiful craters in Africa. And the people who live on this crater are challenged. They face challenges every day. Where is the food going to come from? Where is the water going to come from? Is there adequate shelter? But one of the key things that they have is hope. And I hope that what I've shown you also gives Alzheimer's patients hope. The Foundation has been really critical in advancing our research. And I would say that these donations make donors important partners in our research rather than being bystanders in this research. I also want to now just finish off by thanking Emily for her organizational and technical assistance for these presentations. So thank you very much.
And thank you, Dr. Jhamandas. Your commitment and dedication to finding a cure for Alzheimer's disease speaks to what Amanda said earlier about our role as agents of hope. By supporting your work, our donors are helping to find a solution to one of the most complex health challenges in the world. Our next speaker is Laura Johnson, an associate lawyer at the law firm of Prowse, Chowne, LLP here in Edmonton, which for over 60 years have provided sound and practical legal advice. Laura attended the University of Alberta, and she is passionate about supporting the community in which she works and lives. Laura specializes in the area of wills, estate planning, estate administrative law, and estate litigation. She is well versed in property and commercial law. Laura provides legal estate planning advice to businesses and individuals of all backgrounds. Laura, thank you for joining us today, and I will now pass it over to you.
Thanks very much, Carolyn, for the kind introduction, and to Dr. Jhamandas, that was a phenomenal talk. It was very, very interesting, and I really appreciate all the work that you do. So I'm honored to be here with you all this afternoon. Again, my name's Laura Johnson. I'm a lawyer, associate lawyer at the law firm of Prowse, Chowne, LLP. I actually specialize in wills and estates, so almost this in that area. A little bit done in property law, real estate, corporate commercial, those areas as well. So we're going to go through, my presentation is going to kind of be a series of questions, so typical and fairly simple questions that people ask me when they're coming to me to do estate planning work. We'll kind of look at what goes into an estate plan and how advisors to make that you can give gifts, for example, to the University Hospital Foundation, and just how you can structure your estate the way that you want it to be structured. So it'll just be a series of questions, and we're doing a question and answer at the end. So if you have any questions for me, jot them down, and I'll try to answer them at the end of this presentation. Next slide. So before we transition into my presentation, we thought it would be great to get a sense of the audience current estate planning practices, specifically whether or not you yourself have a will. So the question is up there now. When is the last time you reviewed your existing will? And the options are: I don't have a will. Option B is within the last 5 years, within the last 10 years, or over 10 years ago. So you can go ahead and submit. There's no shame. There's no bad answer.
The results are starting to come in. We will give everyone about 10 more seconds.
Okay, results are in. So 20, almost a quarter. So today we'll be talking a little bit about the importance of having a will. And then, a good chunk within the last 5 years. So that's really good to see. A few within the last 10 years, and 31% over 10 years ago. So I will be talking a little bit about, when you should update your will. And generally speaking, we tell our clients every 5 years, you want to just do a kind of a run through. It's a good time as a rule of thumb to kind of go through and make sure that nothing needs to be changed in your estate plan, and that your will and your other estate planning documents are still reflecting your values and your wishes. Next slide, please. So the very first thing that people ask me generally is, what are the common documents? Like what is this estate planning package you're talking about? What documents comprise that package? So there's 3 main documents that a lawyer like myself would prepare, and that's your will, your enduring power of attorney, and your personal directive. But beyond that, there are a number of estate planning considerations that you should be talking to financial advisors, accountants about. And that's because a lot of your assets that you hold in your lifetime actually fall outside of your estate. So things like joint assets, for example, a house that you may own jointly with your spouse or with a sibling even, if you're on title as joint tenants, it actually not automatically, but with a very simple process, transfers over to that surviving owner on your death. So something like that would fall outside of your will. Similarly, in a joint registered account, or rather a registered account, an RRSP or TFSA, even life insurance policies, you can designate beneficiaries on those accounts. your estate. And so it won't fall into the residue of your estate. It won't be dealt with through your will, but will actually be dealt with outside of your will. So we'll talk a little bit more about that, but just an important note, it's not just these 3 documents, it's kind of a holistic, comprehensive review of all your assets, all your debts. Next slide, please. So what is a will? So of course, the will is the document that everyone's heard about, but essentially a will is a document, it only comes into effect once you've passed away. So you can and you should be updating your will, every 5 years or whenever there's a big change in your life. You have kids, or you have more kids, or you get married, divorced, anything like that, you should be updating your will. But basically all a will is it's memorializing and at one point of time what your wishes are in the event that you pass away or when you do pass away. And so it just kind of sets out where you want your assets to go. If you'd like to make any specific gifts, for example, to a charity like UHF or a charity of your choosing. And also importantly, who will be administering your estate when you pass away. So who has the authority to deal with all of your assets, to access your social media accounts, to take all the steps that are going to be necessary. And so we'll talk a little bit more, I think, on the next slide about some types of wills. So next slide. So yeah, what are the types of wills? So in Alberta, and it varies by jurisdiction, I think I'll stick mostly with Alberta, but in Alberta, there's really 2 kinds of wills. So the first one is the standard will that most of us think about it, and it's the one that's always done at a lawyer's office. And it's typed up in 2 witnesses. Their legal requirements, including who can actually act as your executor under your will. But that will, if you do it at a lawyer's office, one of the benefits is that you're ensuring that all those legal requirements are followed, so that your will be held up by a court and will be clear and easy for your family to follow once you pass away. The second type of will, so that's our first type of will, typed out, 2 witnesses, generally a lawyer, who then swears an affidavit saying that there was no undue influence, that you had capacity to sign the will, and so forth. The second type is a holographic will, and a holographic will is actually a handwritten will, so it's in your own handwriting. It's signed by you and dated. There doesn't need to be witnesses, and those wills do hold up. The downfall with those types often. So maybe you had done a standard will, a typed will years before, and then you want to make a handwritten change. But, perhaps you've written in something that conflicts with the will that you had done before. Perhaps it's incomplete. So there's questions that your family have once you do pass away, and they're trying to, deal with all of your assets. So it is, generally speaking, when someone passes away and they only have a holographic will, we have to actually do a sampling of handwriting to confirm that was in fact your handwriting. So there's some downsides to that. Obviously, a pro is that it's cheap and easy to do and something you can do at home. I think the important thing, and we'll talk again more about the importance of having a will, is to get a will. So if a holographic will is your option right now, then that's a good idea. Who can act as a personal representative in a will? And so when I say personal representative, I generally mean executor. So those 2 words are used pretty interchangeably. Generally, it has to be someone who's 18 and over, someone who has capacity to act, so they aren't incapacitated. And then really you want to pick someone that you trust. This person will have a lot of authority to deal with your assets once you pass away. And someone pretty organized. Being an executor is actually quite a lot of work. It's less work if your will is done in a really organized and clear and concise way. But you want to pick someone you trust, someone who is organized, and you also want someone who's willing to do that job. So it's not a bad idea to talk to your personal representative or your executor beforehand. Say, hey, is this something you'd be willing to take on? Next slide. So this is a little repetitive, but just to make it really clear, what does a will do? So of course, a will only comes into effect once you pass away. So once you pass away, your executor locates that will, and they basically are legally required to follow what is set out in your will. So it's the document that gives your executor the authority to deal with the bank or to access your bank accounts to see how much is in there. It's the authority to give the gifts to charity. So the will is really what is required to ensure that your money goes where you want it to go. And really, that's kind of what this is all about. Next slide, please. Why is having a will important? So part of caring for your family is making sure that things go smoothly for them when you pass away. So sometimes I have clients, they think they have a pretty simple estate, and they say, well, if I don't have a will, what's the worst that's going to happen? And we'll talk a little bit about what does happen. But I think there's something to be said about having a very clear document, and perhaps even a document where you're clear about what your wishes are and what you'd like to happen. Of course, it also overrides what maybe other people think they could be entitled to under your will. So, sometimes maybe you've given the impression to someone that, you'll give them a certain thing, and you're really just, again, a will is a point in time where a written document that outlines your wishes. Next slide, please. What should be included in my will? So we've already kind of touched on some of these things, but if you do your will with a lawyer, the lawyer will ensure that you have all the provisions in there that actually give that authority to your executor to carry out your wishes. So they'll make sure that they're authorized to deal with bank accounts and deal with property. They'll also generally, we never want to have more than one will in place at a time. So generally a provision that's included in your will is a revocation clause, which basically revokes any previous wills. Because again, we want to be really clear that when you do update your will, if you're doing a new will, that the past will be destroyed. And I recommend that if you update your will and you have a new will in place, that past will be destroyed. And of course, whatever beyond the legal requirements, there's a lot of creative ways that we can estate plans for you. You can gift, like we've talked about a little bit, to charities like the University Hospital Foundation. You can gift to, friends and family. You can gift to minor children. So if you have kids who are still little, you can certainly give bequest your estate to them under trust conditions that they'll only receive that money when they're old enough to handle it. So like 30 years old. And so, we can be really creative about how you want your estate to be structured, and that might include a family trust. I'm not going to get too much into detail about those today, but it's basically your wishes. So, next slide, please. So, what happens if you do not have a will and you pass away? It is the follow-up to that. So, if you pass away and you don't have a will, contrary to what some people may believe, no, the province doesn't take all of your money, but it can create a lot of confusion as to who can apply and who has priority under legislation to apply to be the administrator of your estate. So an administrator is basically like an executor, same thing, but it usually refers to someone when there's no will authorizing them. So if you pass away without a will, there's a question amongst your family members about who's in charge of doing this. And sometimes that can be okay. And sometimes that can lead to arguments and kind of some tension within the family. So the legislation in Alberta, the Estate Administration Act, does set out the priority of people who apply. So spouse, but only if you share children together. We have children. It's a big web of regulation. So you would have to look into that to see be required that person might not be who you would want to deal with all your assets. Maybe it's a parent or someone who you haven't had much of a relationship with. So, but it does happen. And then in terms of distribution, there's also rules. It's a separate act. And that act, it's called the Intestate Succession Act. So if you die without a will, you're considered to be intestate, which is kind of a ugly word, but you're considered to be intestate. And so then there are separate rules in a separate act that determine who gets your money. So it's generally pretty, pretty logical, but you're unable to make those gifts to charity, those gifts to friends and family. You're unable to have any control in how your estate gets administered. And I think more importantly, it creates some tension within the family, which is really the last thing I think you want when they're grieving. Next slide, please. And you have multiple wills. So I talked about a little bit, it's important if you do update your will and if you're doing it on your own, that you make sure you have a clause in that will that revokes any previous wills, because the last thing you want is two conflicting wills with provisions that directly compete with one another. So you want to make sure that when you're updating your will, the previous wills are destroyed, but not only that, that there's that revocation clause, I revoke previous wills. You absolutely can have multiple wills, and some, I usually don't advise it. If we can avoid it, we should. Sometimes in terms of if you're a private, if you're an owner of a private business, I've done succession plans that are separate and apart from the will, and that succession or bylaws, whatever else that's governing that company. So sometimes business, if you own your business, there'll be a separate will for that. And then the other case where we see this a lot is in different jurisdictions. So if you have property in the US, if you have property in Mexico, I would actually advise that you go and you speak with a lawyer in those jurisdictions to determine how a will that you do in that jurisdiction becomes binding and what will happen to that vacation property or other property that you might have. Next slide, please. What is an enduring power of attorney? So this is, when I talk about those three documents that the lawyer generally prepares, this is one of them. So I generally recommend you do this at the same time as your will. So unlike the will, which only comes into effect when you pass away, an enduring power of attorney comes into effect if you lose capacity to make decisions about your affairs. So we're typically, we talked a lot, we heard from Dr. A lot about Alzheimer's. And so this is probably one of the most common times that this document is actually enacted. And it's generally doesn't come into force until two doctors sign off that this person has lost capacity to be able to handle their, with this document in particular, it's financial and legal affairs. So I think that's all I need to say. Yeah, next slide, please. Right, the types of enduring power of attorney. So the most typical enduring power of attorney is what's called a springing power of attorney. So, and it's like kind of the one I was just talking about is where you sign it up with a lawyer whenever you do your will, but doesn't come into effect until you've lost capacity to make decisions. So it might never come into effect, but it's a document you have just in case. So it's springing. It doesn't spring into effect until you've lost capacity to make decisions. That's the first type and most common type. There's a second type of enduring power of attorney, which is called an immediate power of attorney. This is often done with maybe specific assets that you hold. Maybe you have a house or you have one account, and you basically just want to give someone the authority to deal with that asset they're still legally capable of making decisions. I've done a capacity assessment. I believe that they understand the nature of the decisions that they're making and the consequences of those, but maybe they're just tired and they're, overwhelmed, and they want a son or a spouse or a daughter to step in and take care of things for them. So in those instances, pardon me, we do an immediate power of attorney, and it comes into effect upon signing. Next slide, please. Personal directive. So this is that third document that typically a lawyer would do for you. This is very similar to the power of attorney in that it only comes into effect if you've lost capacity to make decisions, whereas the power of attorney beforehand dealt more so with financial and legal decisions. The personal directive deals more so with your health decisions, your living accommodations, things like that. Again, this one only, unlike the power of attorney, which can be immediate, this one only comes into effect if you've lost capacity. Please. Who can be my agent in my personal directive? Yeah, so similar to, when you do up a will, you choose your executor. When you do up a power of attorney, you choose who will be your power of attorney. We call them attorneys. And when you do a personal directive, we call them agents. So you have to make a decision who you'd like to be your agent. Obviously, it again needs to be trust. This is someone who's going to be making important decisions about your healthcare if you're unable to do so. In Alberta, they have to be 18. They have to have capacity themselves to deal with things. And in this one in particular, for the personal directive, I always recommend that you talk to the person who you're appointing beforehand, just to see that it's something that they'd be willing to do, and also to have an honest conversation with them about what your wishes actually are and what kind of end of life decisions you'd like made, and because they're essentially legally able, if it's enacted, they're legally able to step into your shoes and make those decisions on your behalf. Next slide, please. Okay, so why is having an enduring power of attorney and a personal directive important? So even more so in some ways than a will, having these documents in place are very, very important, because if not, then there's basically no one. So in a will, and I don't know if I discussed this in detail, but in a will, if your executor can't act and you've named an alternate and your alternate executor cannot act, then the will is still valid. They just need to find someone to be executor. So all your wishes are still valid. But the issue is that you have to find an executor. In an enduring power of attorney and a personal directive, if that you've named as your attorney and your agent, respectively, if they're unable to act, then the whole document is actually voided. So we can't just find someone else and have them apply to be an agent or a power of attorney. So it's important that you have these documents, because if something were to happen, you'd likely be looking at your family members would look at doing a court application to have someone step in to make those decisions for you, which of course can be very costly and very time consuming. Next slide, please. Who should have a will, an enduring power of attorney, and a personal directive? So everyone should. I think in particular, if you have an estate where you do want to do specific gifting, or an estate in terms of the will, or an estate where maybe you're wanting to exclude one of your children for whatever reason, or treat family members a little bit differently, you definitely would want to have a will. Really, if you have kids, it's a minor kids, it's a very good idea to have a will, because the will actually talk about guardianship. If something were to happen to you and maybe your spouse or the other parent of your child, who would be the legal guardian? And this one comes up a lot. And if you don't have that in place, then an application again needs to be done to the court to appoint a guardian, which is stressful and time consuming and very expensive. So I say, yeah, I mean, everyone should have a will. I think generally, whenever life stages change, you get married, you get divorced, maybe you have kids, grandkids, even when your kids become adults, that's a good time to do it as well. And then turning it and personal directive. Again, I think everyone should have that. While in my experience and most of the practitioners I work with, in our collective experience, it's generally our older clients who are experiencing a form of Alzheimer's. This also happens in, car accidents or other illnesses where, the bills need to be paid and money might need to be moved around. And if you don't have these documents in place, it becomes really difficult for your family to do that. Next slide, please. When should you, okay, I already somewhat touched on this, but again, any life change, really, so stages of growth. Like I said, for myself, it wasn't until I got into a long-term relationship and bought a house with my current partner that we decided to get our wills done. So it was just in the last few years that we sat down, did our estate planning. But I have clients who are single and who have assets, and they ask me, and I say, do it. I mean, you work hard for your money, and so you want to have the peace of mind to know that the people who you want it to go to are going to get that money, and that it's going to be easy for your family if something were to happen to you. Next slide, please. So that's it from me. Thank you very much again for allowing me to come and chat with you about estate planning. I'll be here at the end for some questions and answers.
And thank you as well, Laura.
Thank you.
Next, I would like to introduce Rob Campbell, who is the Director of Wealth Management and an investment advisor at Richardson Wealth. Rob earned his Bachelor of Commerce with distinction from the University of Alberta in 1993. He enrolled at Ernst & Young and became Rob worked in private enterprise as a CA in the late 1990s before joining the investment management business. Richardson Wealth strives to provide worry-free wealth to the professionals, entrepreneurs, and families they work with. Through the independent Richardson Wealth platform, they utilize exclusive investment, tax, estate planning, and insurance solutions, all developed around the cornerstone of comprehensive and customized wealth planning. Thank you for joining us today, Rob, and the floor is yours.
My apologies, you froze on me. I hope my connection is okay. Thank you for the kind introduction. Like Laura mentioned, I'm very honored to be part of this panel and to have the opportunity to hear Dr. Jhamandas' insightful insights about the progress in the war against Alzheimer's. It was encouraging and inspirational. Unlike Dr. Jhamandas talking about a hopeful but uncertain future, I'm going to be talking about death and taxes, a little more certain and a little less hopeful, but nonetheless, it's part of all our future. In order to do that, I'm first going to give a brief introduction to my firm, Richardson Wealth, and our team there, Campbell Wealth Management. I'm going to talk a little bit about the tax implications on death and what happens from a tax perspective when you die, because we need to sort of lay a groundwork to understand some of the strategies that I'm going to talk about to handle that process efficiently. And then I'm then going to talk about a few tax-effective philanthropic strategies for you to consider when deciding to do with, and then talk about a few other estate planning considerations. So that's what I have planned for today. Next slide, please. So first of all, Richardson Wealth. So we're the largest independent wealth management firm in Canada. We manage around $35 billion in assets on behalf of families across Canada. We are significantly employee-owned, which is a big differentiator of our firm. And we do have an open architecture and we're independent. That means we act as independent agents for our clients and never invest in Richardson Wealth securities. Instead, we shop the market for the best solutions for our clients. And that independence has allowed our firm to become, to my knowledge, still the only Financial Services Canada and firm in Canada that's been able to achieve our fiduciary designation. So we're licensed fiduciaries recognized by the Centre for Fiduciary Excellence. Next slide, please. We do have offices across the country, and as you can see on the slide, we work with over 40,000 Canadian families and individuals in 19 different markets. Next slide, please. My team, Campbell Wealth Management, is based out of our Edmonton office, and we're a team of 5 that work together. We do take a team-based approach to delivering solutions to our clients. And one of the major cornerstones of what we do is around wealth planning, tax planning, and strategic decisions for managing your wealth. And of course, a key part of that is working through philanthropic strategies with our clients and also tax effectively handling their estate decisions. Next slide, please. So now we're going to learn a little bit death, a very exciting topic, I know. Next slide, please. So the first thing to note is with a couple, when the first member of a couple dies, there's actually no tax consequences. CRA allows assets to roll over to the surviving spouse without any tax implications. And so on the first death of the spouse, we don't need to worry about tax. It's really on the death of the second spouse or an unmarried individual where you've got tax concerns with your estate. Next slide, please. So on the death of the second spouse or someone who's single, the first thing to note is you're taxed on capital gains on any securities that you hold. Now, capital gains, fortunately, are taxed at an attractive 1/2 inclusion rate, so they are taxed favorably. However, they can still create a significant tax bill for an estate, particularly in a couple of examples. Often we have clients that have held individual securities for many years that may have large gains on them. For example, some of the guests in the audience may be of an age where they remember when TELUS first went public. And many Albertans bought shares of TELUS, and some Albertans are still holding on to those shares many years later. Well, if you hold a public market security that you've held for years and has a large gain, that's deemed to be disposed of in the year of your death, and you're taxed on that gain. The other thing that can really surprise people is that you're also taxed on the growth in value of private company shares. Now, those private company shares can include if you're an owner of a business that's grown over the years of any size or shape. But the other thing a lot of people don't realize is it also includes professional corporations where many physicians, lawyers, and other professionals have the opportunity to earn their income in a professional corporation, and they're in fact taxed on the growth and value of that professional corporation when they pass away. So although, as mentioned, capital gains are taxed favorably, there can be some surprises if you're not prepared, depending on what type of securities you hold and what type of investment and business interests you hold. The other thing that is very important to be aware of is that all of your registered assets come into income in the year of your death. Now, I want to be careful when I'm talking about registered assets, I'm talking about RSPs or RIFs, which at age 71, your RSP has to convert into a RIF. I'm not talking about tax-free savings accounts, which are also registered assets. I just wanted to clarify that. But what happens in the year that you die is that the entire value of your remaining RIF is included in your income. And that comes into your income at your highest marginal rate. So that can be very punitive in terms of the tax bill for your estate. Next slide, please. Now, this is a busy slide, but we're really just going to focus on one column, the other income column, and the first column showing income bands. Now, in Canada, what happens is we have what's called a marginal tax rates. So the more you earn in a year, the higher tax you pay. So you can see that as your income goes up, the rate of tax that you pay on each incremental dollar of income goes up as well, topping out at 48% in Alberta for income over $315 or around $315,000. But it's interesting to see that even over $98,000 income into $6 dollars. So it's really important to understand that the more income you have in a year, not only the more tax are you going to pay, but the higher percentage rate you're going to pay on each dollar of income. Next slide, please. So let's look at an example. Now, if we consider an Albertan who had $500,000 in registered assets and they were retired, that registered asset being an RSP or a RIF, they probably wouldn't consider themselves wealthy. Yet it's interesting to see that if that person died with a $500,000 RIF, because of those increasing marginal tax rates, they're going to pay over $205,000 in taxes. And a lot of people are shocked by that number when they don't consider themselves a very wealthy person in the grand scheme of things. Next slide, please. Now, one other thing to note before we get into some strategies is that life insurance is one of the few things that CRA hasn't attacked from a tax perspective. When you own a life insurance policy, the proceeds of that life insurance policy go to your estate tax-free. In addition, there's types of permanent insurance policies where you can have an investment component building within it, and that investment component all grows tax-free. Most tax strategies in our country, things like RSPs, are all about deferring tax. So you get tax shelter when you fund the program, but eventually you get taxed on it. In the case of an RSP, either at your death or when you pull money out. So life insurance is still sort of the one golden option where there is no tax on life insurance in Canada. And so that's going to be key to one of the strategies we're going to look at. Next slide, please. So now that we've covered off a few of the basics of taxes and what happens when you pass away from a tax perspective, we're going to get into a few strategies to think about. Next slide, please. Oh, and I did want to note that I'm going to run through a number of examples here. And it's important for me to just let you know that when we're talking about tax rates, costs, results of these various strategies, they really do depend on each individual's unique financial, tax, and health situation. So while these strategies are interesting and hopefully some will get you thinking that perhaps they apply to you, I would ask that you make sure to speak with your advisors in the context of your personal situation before proceeding with any of these strategies. Next slide, please. So the first consideration is to give away your money while you're alive. There's some significant advantages to that. One of the first and foremost is to be able to see and enjoy the benefits of your hard-earned wealth, whether you're giving it to a charitable organization or to a family member. Now, what's interesting is when you're giving money away while you're alive, it can also reduce tax even when you're giving it to family members. If you think about the example of a security with a large capital gain, if rather than selling it, having it notionally sold in the year of your death and realizing that large gain and having it subject to tax, instead you're selling a bit of it each year, you can potentially be doing that at lower tax rates. That same concept to your RIF, if you're money out beyond what you need to live on, but drawing it down so that you don't have so much coming into income in the year of your death, that can be very beneficial, whether you're gifting to family or to a nonprofit organization. And of course, the benefit of donating to a great cause like the UHF or other nonprofits is that you also receive a donation tax credit on donations that you make, which provides a very powerful tax deduction and tax savings for you. Next slide, please. So we're going to look at, kind of follow through on that example that I talked about with a $500,000 RIF. Now, if you don't do anything, as I talked about, you're going to be facing a $206,000 tax bill on your $500,000 RIF. Now, if you were in a situation where you had enough other assets to look after your beneficiaries and provide for your family members, you might consider donating that RIF directly to charity. Now, what's great about that is you would get a donation receipt on the entire $500,000, which would eliminate that $206,000 tax bill. So you would be able to gift the entire $500,000 to a nonprofit or a charity and not pay any tax at all on that amount. So that would be, obviously can kind of supercharge your philanthropy if you choose to donate registered assets directly to a nonprofit organization. Next slide, please. Now, again, this is a little bit complicated, but there's another advantage. Again, if you have a public security with a large capital gain, like that TELUS example I referred to earlier. So you may be thinking that you no longer need those, or estate is looked after, and you want to give a gift to a nonprofit organization. Now, in the example on the left-hand column, we're going to look at a security that you originally bought for $10,000, and it's worth $50,000 today. Obviously, a very successful investment, or perhaps it's something you've held for a very long time. So your capital gain on that security is the difference between the cost and the value, which is the $40,000 differential, which you'd be on as a capital gain if you sold the security. So your first option is to sell the security, in which case you pay $9,600 in tax. You would then have $40,400 to donate to a nonprofit. And that would result in a $19,392 tax credit on your tax return. So you'd still be able to do a lot of good and get a significant tax credit to help you with your taxes. But one of the unique advantages that CRA has set out in the Tax Act is that if instead of selling the security and donating the proceeds, if you choose to donate the security directly to a nonprofit, CRA will waive the capital gains tax. So you don't pay any tax at all on that $40,000 gain. Now, there's a couple of advantages to that. So first and foremost, the nonprofit of your choice is getting a security worth the full $50,000. They're not just receiving the $40,400 in after-tax proceeds. And in addition, you receive a larger charitable donation tax credit for $24,000. So that's extremely beneficial for you to donate that $50,000 security on an after-tax basis. It would only cost you $26,000. So some very tax-effective gifting. Next slide, please. I'm going to talk a little bit about using insurance to fund a charitable donation death. I'm going to look at an example to do so. Next slide, please. So in this example, we're going to consider a couple, a male age 70 and a female age 68, who are both non-smokers with a $500,000 RIF, like the one we looked at in the earlier example. And that could even be a combination of a $250,000 RIF each, because again, it's all going to come into tax on one tax return at the end of the day. Now, what we're going to look at is the impact of this couple buying $500,000 of permanent life insurance to utilize for their philanthropy. Now, when you buy permanent insurance that's designed to assist with your estate, you typically use something called joint and last to die insurance. What that means is we would actually insure the lives of both partners in the example above. So both the age 70 male and the age 68 female would be on the policy. So what that means is there's no payout when the first one passes on, and instead the payout happens on the second death, which of course is when the tax problem arises. Now, the advantage to doing that is that because the insurance company is actually insuring two lives, you can actually access insurance at a much cheaper rate than either of the two individuals would be able to on their own life. Now, the cost of the example policy I'm going to talk about is $12,000 a year, roughly. Of course, that's a significant commitment, and I'm going to circle back to that. But I just wanted you to have some numbers in mind as to what that type of insurance policy might cost at that age. So next slide, please. And again, we've seen that if they had the $500,000 RIF and no insurance, they'd be faced with a $206,000 tax bill, and their estate would net $294,000 to go to their beneficiaries. Now, if the couple in question chose to direct those $500,000 of insurance proceeds to a nonprofit, that would completely eliminate the $260,000 of tax that the estate would pay. What that means is not only are you doing a great support or providing great support for an awesome cause like the University Hospital Foundation or another nonprofit, but you're also leaving your estate whole for the benefit of your heirs. And so then it becomes a consideration of whether you have the ongoing cash flow, perhaps from a pension or other sources, to fund that $12,000 a year to your life expectancy. So let's look at that for a moment on the next slide, please. So life expectancy for that couple is actually at year 23. So after 23 years of having that insurance policy, you would have spent $279,000. Now, what's interesting is not only is that those insurance proceeds doing a great service to a nonprofit, but it's also interesting that they're a pretty good investment. Because of the tax advantages within the insurance policy, the $500,000 payout actually is equivalent to an 8.5% GIC return after tax. So to have a similar type investment over those 23 years, you would need to be putting a little over $12,000 a year into an 8.5% GIC in order to wind up with $500,000 to give away at the end of your life. So insurance can be a very, very cost-effective nonprofit organization of your choice. Next slide, please. So now I'm going to just talk about another couple of estate planning considerations, sort of between the taxes and the will, and just a couple things for you to be thinking about. Next slide, please. So first of all, here in Canada, there's a new feature for investment accounts, which our firm, Richardson Wealth, has adopted, and I believe others are starting to as well. But you can name a trusted person on your investment accounts. Now, this topic is particularly salient today after the stats that Dr. Jhamandas shared with us that 1 in 3 Albertans over the age of 85, or maybe even as many as 1 in 2 Albertans, are impacted by Alzheimer's. Now, what the risk is if you're an unmarried individual or your spouse has passed and you're dealing with cognitive impairment, you may not know that. And it could be very difficult for your advisor because an investment advisory relationship is a very private thing. Your advisor is not allowed or eligible to talk to others about your accounts or your wealth or anything to do with them. So what this allows you to do is to name a trusted person, perhaps a family member, perhaps a trusted friend or a professional you work with. And what that does is that empowers your financial advisor that if they're speaking with you and if you're giving directions that just don't seem to make sense or don't seem to be beneficial to you, they can then reach out to your trusted person to confirm that that advice is accurate and should be followed through on. It's also a bit of a sad state of affairs today that financial fraud is common in society, and we're seeing it increasing at people. The term for it is elder abuse. And this can also be a helpful situation if a person is under some type of duress or being defrauded. If the spidey senses of your advisor are up, they can be speaking with your trusted person to make sure there isn't an issue. So I would encourage you to investigate that with your advisor and to name a trusted person on your investment accounts. Next slide, please. Now, I've talked a lot about giving your money away, which is a great thing, and I admire people with philanthropic goals. However, it's also important that you need to ensure that you have and will have enough to live on through the duration of your life. And so what we really encourage for our clients and all individuals is to consider going through a comprehensive wealth planning process and developing a comprehensive wealth plan, where you project the growth and drawdown of your wealth through retirement. You project major needs and uses of your wealth through your retirement years. And you also project the tax burden on your estate, what's going to flow through to your beneficiaries, and how that's going to work. Now, the big advantage to that, of course, is it puts you in a position to confidently be able to do things like name a nonprofit like the University Hospital Foundation in your will, knowing that you can do that, yet not leave your beneficiaries and family in a difficult position, or yourself in a difficult position, depending on your longevity. And no doubt, as Laura made abundantly clear, a will is absolutely vital. And even in spite of how vital a will is, we see that a lot of people still don't have them. But in my experience, a will is still much more common than a wealth plan. However, a wealth plan, in my view, is also integral to the state, help you achieve your goals, particularly if you do have philanthropic desires in the context of your estate, while also being efficient from a tax perspective. So putting together a wealth plan is another really good idea. Next slide, please. Just a bit of a quick summary for you. So consider funds while you're alive. It's more fun. You get to see the benefit of it. Don't forget the tax benefit of charitable donations in your estate. When you're sitting down with Laura, certainly speak with them about that if you have philanthropic goals. Don't forget the benefits of gifting securities with embedded capital gains. That can happen while you're alive, but it can also happen through your will and your estate. And don't look past the tremendous benefits of utilizing life insurance to support your philanthropy if you have goals of designating nonprofit organizations as beneficiaries of your estate. And as I've just talked about, consider naming a trusted person on those investment accounts to protect yourself as you age. Although hopefully for all of us, Dr. Jhamandas and his team will be far ahead of this. We won't have to worry about things like Alzheimer's down the road. And lastly, make your estate decisions in the context of a comprehensive wealth plan so that you're making them efficiency and with the confidence of knowing that you and your loved ones are looked after. Next slide, please. So I will finish with that, and I would just like to say thanks again to Carolyn and her tremendous team for inviting myself to represent our team and our firm here. And again, I'm honored to be part of such an esteemed panel of guests with Laura Johnson and Dr. Jhamandas. Thank you so much. And thanks to all the guests for giving me your time today. I appreciate it.
Thank you, Rob and Laura, for all of the wonderful information you have shared with us. Like everyone else here today, I'm looking forward to hearing more from both of you as we move into our question and answer period. So my name is Kathy Clarko, and I'm a member of the development team at the University Hospital Foundation, and I will be moderating the question and answer portion of today's program. As mentioned earlier, you should see a question and answer box at the bottom of your screen. So please use that to enter any estate planning questions that you have for either Rob or Laura. And we will do our best to get through as many of the questions as our time together today allows. So the first question for Laura is, what is the Act for intestate estate issues?
Yeah, so we talked a little bit about the intestate. If you become intestate, that means you pass away and you haven't had a chance to do your will yet. So you're considered intestate. It's a little bit complicated, but there's two pieces of legislation that step in. So the first is called the Estate Administration Act. So I'm talking about Alberta. So this is Alberta legislation, Estate Administration Act. And that dictates the priority of who can apply for administration of your estate. So it generally is spouse and then kids, and then it goes to parents, and it has a whole lineation of that. The second piece of legislation is the Wills and Succession Act. So that determines, I think it's part 3 of the Wills and Succession Act, determines who actually gets all of your stuff when you pass away, if you don't have a will.
Great, thank you. We've got some great questions coming in. So Rob, I'll flip this one over to you. You talked about a married couple versus a single person. What about a common law couple?
A common law couple is considered under tax the equivalent of a married couple. It doesn't matter at all. So yeah, a common law couple has all the same rights as well as obligations from a tax perspective as a married couple would. Good clarifying question. Thank you. And I'm glad no one is asking about the Tax Act, because I don't know if I can rip off sections like Laura. So
Wonderful. Well, Laura, here's another one. How do you ensure no one can contest your will? This question comes from someone: we have no children and would want our estate to support our philanthropy decisions.
Sorry, my sound just cut out for a second. I don't know if you're asking me a question.
Yes, I'll repeat it.
Oh, my apologies.
That's okay. The question is, how do you ensure that no one can contest your will? We have no children and would want our estate to support our philanthropy decisions.
Yeah, so the starting point is that the only people who have automatic standing to dispute a will is your spouse or adult interdependent partner and your minor children. So in Alberta, and this varies a little bit by jurisdiction, but in Alberta, provide for those children. If those were adult children, then the adult children don't have automatic standing to challenge the will. In places like BC, they actually do. But to ensure that no one contests your will, you want to make it very clear about what your wishes are. If you're naming charities, put the full name. Make sure you even reach out to the charity to get the full legal name of that charity, and even a CRA, if it's a registered charity, a CRA number to put in your will, just to make it very your money to go. But generally speaking, unless you're a dependent child, so a minor child generally, or a dependent adult child, maybe a child with a disability or a spouse, there's no automatic standing to challenge somebody's will.
Wonderful, thank you. There's a lot of really great questions, so we'll go through a few more here. Could you explain the benefits of setting up a trust as a way to distribute assets over time? For example, with a trust, your beneficiary would not have to wait for a property to go through probate.
I assume that one's for Laura.
Yeah, I can take that one.
Yeah.
Yes, certainly. You can certainly set up a trust. And you can hold assets in that trust. And when you do pass away, you can specify where those funds are to go, who is to be in charge of administering that trust. So it's a really good tool to use. There can obviously be a lot of tax benefits as well. One of the main downfalls, and sometimes it's a lot of work to set up in the first place. So often a lawyer will charge a lot more money to do that. But once in place, it can be a really valuable tool.
Okay, great. Rob, sorry, I'll clarify. Rob,
no worries.
One of our participants has asked about donor advised funds. Can you tell us how that may be beneficial to someone in their estate planning process?
You bet. That's a great question. What donor advised funds do is really allow somebody to effectively set up an endowment to support their ongoing philanthropy in the future, but to push forward all the tax benefits of those future gifts or charitable support. Now, what I mean by that is the year you set up a donor advised fund, you make a sizable contribution to it, and you get the entire donation tax credit in that year against your tax return. So this can be particularly effective if perhaps you sold a business or for some other reason are having a significant high income year. but also just at any time, it can be a really great way to significantly reduce your taxes in a particular year. Now, the other advantage of a donor advised fund is when you set it up, you still control and oversee the funds, and you can then decide on your gifting each year going forward. So donor advised funds can actually be a really good tool as well to integrate your family and perhaps your children into your philanthropy and gifting strategy and circle them into both the management of the fund and discussions around what organizations you're going to support each year, and almost sort of start laying the foundation for discussions around eventual transition of wealth, particularly for people with significant wealth, to their children, to start teaching them not only some financial responsibility, but also the importance of philanthropy and doing some good in our community.
Great. Okay. Laura, if a charitable organization is not mentioned in someone's will, but the executor or the family would like to make a donation through the estate, is this allowable? And if it is, who receives the charitable tax receipt?
So you're saying if it's not outlined in a will.
Right. So if it hasn't been outlined in the will, but the executor or the family would like to make a donation through the estate,
I see.
Can that happen? And if it can, is there a charitable receipt, or who would receive the charitable receipt rather? I think we may have frozen. Yes. Okay. Well,
I wish I could answer that one, but that's a specific legal one.
Yes.
So I'm not touching
yes.
it.
Well, hopefully, we had lost you. We thought we had lost you, and now you came back.
My apologies. I've been having a little bit of technical difficulties, so I was just talking away. But can you hear me now, Kathy?
Yes, now is great. If you wouldn't mind, we didn't hear any of the answer. Thank you.
So,
I think we've lost her again. I'm not sure if that's just me. I
can't hear her either, Kathy.
Okay.
Just so you know.
So maybe Rob, I'll quickly move on to a question for you.
Sure.
Someone is asking, where can they get a comprehensive wealth plan, and how much does it cost?
Typically your financial advisor or investment advisor would work with you to prepare that. At our firm, that's sort of part and parcel of the services we provide when we work with our clients. It's a really great way to set the foundation for how we're going to work together and get a deep understanding of our clients' needs and goals. That said, we also at our firm will do fee-for-service comprehensive wealth plans. If someone doesn't want to become a client but wants the wealth planning work done, we can do that. And the range in cost is perhaps from around $2,000 to around $4,000, depending on the complexity of somebody's situation. We'd be able to do perhaps something simplified for less, or maybe do a briefer consultation. But for a full wealth plan for somebody with a fairly complex situation and significant wealth, that's sort of the range you're looking at.
Okay, great. Laura, I think maybe we can try one more time. I'm not sure if you can hear it.
I can hear you. Can you hear me okay?
Yes. Now we can. So should we try that one more time?
It's cutting a little bit in and out. I'm so sorry.
That's okay. No worries. It's technology.
But yeah, I can field another question if you'd like, Kathy.
Sure. Can we try to go back to the charitable organization not being mentioned, what the options are?
Yeah, I'll chat quickly. So if it's not mentioned in the will, then the executor has no authority to start giving out money to charity. You can add, if you're not sure what charity, you can add a general clause in there that basically sets out that you'd like some money to go to charity, and you leave it up to your executor to then decide how to do that. So if you're not sure which foundation or charity,
I think we've lost her again, but I think we got the gist of that. You can't you can't just be spending other people's or making those decisions. So, okay, well, I think thank you so much, everybody. That's all the time we have for your questions today, and we appreciate you being here with us. Thank you.
Thanks, Kathy. It was a pleasure, and thanks again to all the participants who've logged in. We appreciate your time.
Thank you very much.
And thank you, Kathy, for being our Q&A moderator. On behalf of Amanda, Kathy, Emily, myself, and of course our very special guest, Dr. Jack Jhamandas, Laura Johnson, and Rob Campbell, thank you for your time and active participation. We hope you found today's session informative. As a reminder, within the next few days, we will send out a recording from today's virtual seminar. And we'll also send you a very short survey that we hope you'll let us know how we did. If you want to learn more about us, please reach out by email or visit our website at give2uhf.ca. You can watch events on the University Hospital Foundation's YouTube channel. We're excited to share with you that our next virtual event is on November 16th. It's our virtual expedition on neurorehabilitation, this year's Festival of Trees cause. We hope you'll tune in. Today, we've learned how including a gift in your will can have incredible tax benefits and also have major impact on healthcare at the University of Alberta hospital site. Planned gifts ensure that innovators like Dr. Jhamandas will have the means to pursue breakthroughs, advance patient care, and transform health in our community and around the world. I am proud to share with you that in the last 5 years alone, nearly $15 million from generous donors who have left us gifts in their wills have supported advancements in patient care and research at the University of Alberta hospital site. Thank you so much for joining us today. And to conclude our session, we will leave you with a 1-minute video entitled Ignite 2030. Have a wonderful evening, everybody.